Well, friends, the justice gods giveth, and the justice gods taketh away. On the point of light front, E. Jean Carroll just whooped Donald Trump in court again to the tune of nearly $90 million. But on the darkness front, the Supreme Court just announced in substance that the constitutional rights of immigrants don't really matter. They do matter. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, let's start with the good news. E. Jean Carroll just beat Donald Trump in court again. I believe that is for the fourth time. You know, if only the Republicans in Congress had 1/100th of the courage and determination of Miss Carroll, we might be able to end our long national nightmare. But alas, let's start with the new reporting. This from Politico. Headline: Trump loses bid to overturn $83.3 million E. Jean Carroll defamation judgment. A three-judge panel of an appeals court rejected Trump's attempt to toss out the judgment using presidential immunity. And that article begins: a federal appeals court on Monday upheld an $83.3 million judgment against President Donald Trump for defaming the writer E. Jean Carroll, rejecting the president's argument that he should have been protected by presidential immunity. The judgment, issued by a federal jury in 2024, stemmed from comments Trump made during his first presidential term in response to Carroll's allegation that Trump raped her in the 1990s. Trump repeatedly denigrated Carroll, claiming he had never met her, and said Carroll's memoir, in which she discussed the rape allegation, should be sold in the fiction section. A federal judge ruled that Trump's comments were false and defamatory, and a jury ordered Trump to pay Carroll the 8-figure civil judgment. In a 70-page decision, a three-judge panel of the Second Circuit Court of Appeals wrote that the jury award was fair and reasonable. With interest, Trump now owes $89.7 million, according to a spokesperson for Carroll's lawyer, Roberta Kaplan. In a statement, Kaplan said, "We look forward to an end to the appellate process so that justice will finally be done." The judicial panel rejected Trump's efforts to have the judgment overturned based on the Supreme Court's landmark decision last July on presidential immunity. Last year, a different panel of the Second Circuit upheld a separate $5 million civil verdict against Trump for sexual abuse and defamation claims brought by Carroll. And friends, maybe to put an exclamation point on their conclusion that $83.3 million was, quote, fair and reasonable for what Donald Trump did to Miss Carroll, here's what the judges wrote. Trump's attacks against Carroll were not isolated. Rather, they continued throughout the pendency of the nearly 5-year litigation and became more extreme and frequent as the trial approached, the panel wrote. They noted that he continued his attacks even after he was found liable for sexual abuse and defamation, and even during the second trial itself. And now, friends, the $64,000 question, or in this case, I guess it's the nearly $95 million question when you add together the two judgments that E. Jean Carroll won against Donald Trump, is: will the Supreme Court reach down, grab hold of this case, and, I don't know, expand Donald Trump's immunity? Maybe to include civil lawsuits as well, because what we know is the radical right-wing 6-justice majority on the Supreme Court is forever trying to expand Donald Trump's power and do Donald Trump a solid. But let's be clear, their presidential immunity ruling, which essentially ruled that the Constitution is unconstitutional, it violated the express language of the Constitution, that ruling only applies to criminal prosecutions. It absolutely does not apply to civil lawsuits. But is there anybody out there who is willing to place a bet on whether the Supreme Court, now that it may have the opportunity to bestow even more immunity on Donald Trump, is there anybody who would bet that they're going to do the right thing and say, hell no, we're not going to accept this case for review? There is no constitutional principle that we need to address in these two cases in which E. Jean Carroll mopped the floor with Donald Trump. Stay tuned, friends. We'll see what the Supreme Court does with this one. Okay, friends, let's turn to the darkness and that same 6-justice majority that just ruled in substance that if you look Hispanic, if you speak Spanish, or if you speak English with a Spanish accent, and you happen to be in the vicinity of where day laborers are, then you don't really have the same constitutional protection against an unreasonable search and seizure that everyone else has. Let's start with the new reporting. This headline from NBC News, headline, Supreme Court lifts limits on roving immigration patrols in Los Angeles area. The decision prompted liberal Justice Sonia Sotomayor to say in dissent that she would not stand idly by while our constitutional freedoms are lost. And friends, before I read that NBC News reporting, I want you to hear that reporting about the Supreme Court overturning what a trial court did and what a court of appeals did. I want you to listen to what the Supreme Court just did against the backdrop of what the trial court found the Trump administration was doing in LA. Here is a short passage from an AP article. U.S. District Judge Frimpong in Los Angeles have found a mountain of evidence that enforcement tactics were violating the Constitution. The plaintiffs included U.S. citizens swept up in immigration stops. An appeals court had left Judge Frimpong's ruling in place. And now, friends, here's what the Supreme Court just did with Judge Frimpong's ruling as affirmed by an appeals court. The Supreme Court on Monday blocked a federal judge's ruling that restricted federal officers' ability to conduct immigration stops in the Los Angeles area, prompting a harsh rebuke from liberal Justice Sonia Sotomayor. The decision to grant an emergency request filed by the Trump administration puts on hold the July 11 ruling by Los Angeles-based U.S. District Judge Frimpong. Attorney General Pam Bondi welcomed the decision, saying in an X post that it means immigration enforcement agents can continue carrying out roving patrols in California without judicial micromanagement. No, Pam, it actually means that law enforcement agents can continue conducting roving patrols, violating the constitutional rights of the people, American citizens and undocumented immigrants alike. My editorial edition, because that is what's really going on. Back to the article. Justice Sotomayor, the first Hispanic to serve on the court, was joined in dissent by the court's two other liberals. Quote, "We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job, rather than stand idly by while our constitutional freedoms are lost. I dissent," she wrote. The Constitution's Fourth Amendment, which protects against unlawful searches and seizures, should protect everyone, Justice Sotomayor said. Quote, "After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work a certain type of legitimate job that pays very little," she added. Judge Frimpong had ruled that immigration agents could not stop people purely because of their race, ethnicity, or that they speak Spanish, because of their work, or because of the places they congregate. The lawsuit was filed in response to extensive sweeps carried out by federal agents in the Los Angeles region as part of the administration's hardline immigration policies. Immigrants and related groups that sued claimed the government's approach violated the Fourth Amendment, which requires law enforcement to have reasonable suspicion before stopping people who may not be lawful residents in the United States. The Ninth U.S. Circuit Court of Appeals declined to block the decision of Judge Frimpong on August 1st, prompting the Trump administration to turn to the Supreme Court. You know, friends, it really does feel like those 6 right-wing justices are hell-bent on rewriting the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. It sure looks like the 6-justice majority is determined to add, unless you look a certain way, talk a certain way, and are a wage earner. Friends, the only very faint point of light, little sliver of light here, is this is not a final ruling. This is a ruling that pertains to Judge Frimpong's injunction, which the Supreme Court has now trashed. But the case, these issues are still being litigated in the lower courts. And yes, that is a very faint point of light, but one that we will hold fast to for the time being, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with y'all again tomorrow.